Hello, everybody. Hello. Thank you all so much for coming to our first of the 2019-2020 LPO Colloquium Series. I'm very, very pleased to welcome Professor Julie Mead, who's Professor of, make sure I get this right, Education Leadership and Policy Analysis and Associate Dean for Education at the University of Wisconsin-Madison. Professor Mead is an expert in education law, both with respect to special education and school choice. And I will turn it over to Professor Mead, who has wonderful information to share with us about topics that relate to all of our research and studies. Professor Mead.
Thank you very much, and thank you for the invitation. It's delightful to be here. It is my first trip to Vanderbilt, so I'm having fun just getting to see all of the places around campus. If you're curious, that's the University of Wisconsin-Madison on Lake Mendota. So we're right along the lake. Let's see if I can find it again. So that is the education building right there. So fun place to get to hang out. So as the title says, I'm going to take you, and can everybody hear me okay, or do I need to be by the mic? I don't tether very well, so I prefer to roam, but if I need to stand still, I will. At any rate, as the title says, I'm really going to take you on a little bit of a tour of thinking about how the Constitution and school vouchers and student rights all kind of all together, how that all works. Which means I'm going to take us on a little bit of a historical bent as we go through those. As I do so, these are really the questions that are animating a lot of the work that I do. And so what I really want to know is when a university, or when a state, adopts a voucher or a voucher-like program, what's it mean? What does it mean for student rights? Are we creating or replicating systems, or are we changing systems? What does it mean in terms of the trade-offs that are happening when a state adopts that program? And of course, what are both the intended and unintended consequences? Now, I work, of course, in the state of Wisconsin, which has not one, not two, not three, but 4 voucher programs and a tax credit on top of that. And in fact, the Milwaukee Parental Choice Program was the first publicly funded voucher program, modern voucher program. I'll explain kind of the historical ones. But it was the first real experiment, as the legislature called it in 1990 when it was enacted, to test Friedman's idea about school choice and market principles. So before I go any further, let me just explain what I mean by voucher and voucher-like programs. So we start with vouchers, and you see how each one of them works. In particular, when we talk about voucher and voucher-like programs, and full disclosure, from now on I'm just going to call them all vouchers, right? Just get them all together. So first were the voucher programs like the Milwaukee Parental Choice Program or the Cleveland Scholarship Program. And that's where a statute sets an amount of money, that is the voucher amount, and that voucher then can be used to pay tuition at a private school. Now, depending again on how that voucher program is structured, the participating private school may have to accept that voucher amount as full payment of tuition regardless of what they charge other people, or they may still permit the statute may permit the school to charge additional fees over and above that voucher amount. Again, just depends on what the state has. The second kind that happened historically, actually preceded, is a tax credit or tax deduction programs. Those, again, depending on what the state statute says, is going to provide those kinds of benefits. Then the tax credit scholarship programs, those are sometimes, Kevin Wellner out of University of Colorado calls them neo-vouchers. And those programs create a middleman. So instead of having the statute set a voucher amount that then gets transferred to the school, this allows taxpayers, either corporate or individual, to designate a portion of their tax liability into a scholarship fund, and that scholarship fund then pays for the voucher or the tuition. And then the newest kind are education savings account, which is what you have here in Tennessee. Although, as I was mentioning to somebody earlier today, your newest one that was just enacted, interestingly enough, and I haven't dug into it deeply enough, but the EdChoice website categorizes that one as a voucher, even though the name says education savings account. So one of the things that I'm need to do is to dig into your statute to see how I would categorize it, where it would go. But given its name, that's where I put it today. And those programs, again by statute, usually take an amount of state aid, often the average amount of state aid that would have followed a child into a public school, and make that available to parents to spend on educational expenses, as long as those educational expenses are not public school expenses. So they require withdrawal from the public system. So when I say voucher and voucher-like programs, that's what I'm talking about. Also, I had provided a chapter that I recently wrote for an Oxford Handbook that I shared with you, but actually what I'm going to talk about today kind of blends all of that different work. So I'm pulling it all together. If you want links for any of the other things, I'll be happy to provide it to you. So let's get started. And to get started, again, those are the questions. But we need to really think, how did we get here? How did we get to where we are with all those voucher and voucher-like programs? And we're going to start in what may be considered an odd place. We're going to start with the doctrine of Parens Patriota. So this is a common law doctrine. It's the doctrine that permits state legislatures to legislate for the general welfare. It's this concept that the state is the parent of us all, and that means that sometimes the state has interests that are independent of the individual's interests. Sometimes maybe in tension with the individual's interests. It's Parens Patriota that permits states, for example, to enact and even to change vaccination requirements, right? That's a hot topic that's been going on. It's Parens Patriota that allows a state to require that when you get into your car, you buckle up your seatbelt. Those seatbelt laws are expressions of Parens Patriota. And it says there, as it says there, because the state has an interest in educated citizenry, it means, in fact, that they have the ability to dictate, to some degree, some of those educational obligations of each of its citizens. And that if I, as a parent, as the example says there, said, who needs to be educated? We don't need education. That could be found to be out of compliance because, of course, the primary way that we express Parens Patriota is through compulsory ed statutes. So compulsory ed statutes, of course, you have lots of other things, health and safety, personnel requirements, standards for what is to be taught, how we're going to assess what is to be taught, even the definition of a private school, what counts as a private school, is something that the state does through its Parens Patriota authority. Now, when courts have looked at whether or not an expression or a law that they've created is permissible, constitutionally permissible, the standard that they're held to is one of reasonableness. So is the rule reasonable given the rationale or the goal that they're trying to do? Now notice, reasonable does not have any analysis about whether it's wise, whether it's effective, or whether it's stupid. Doesn't matter. If it's reasonable, as long as it's reasonable, or as the court would say, rationally related to a legitimate state interest, it's going to be upheld. But even reasonableness has a boundary, and there are things that are unreasonable, and you could argue that the first case that laid out issues of school choice was on this particular issue, on Parens Patriota, Pierce versus the Society of Sisters, 1925. The state of Oregon had enacted a statute that said you could only satisfy compulsory education by going to a public school. Supreme Court said, too far. Yes, you have an interest in an educated citizenry. Compelling just one kind of school is not rationally related to that. And so therefore, they said, can't do that, right? So even though reasonableness is a fairly low standard, it still has boundaries. It's still a boundary for state legislators. And by the way, we were chatting before. If you have a burning question that can't wait until I'm done, feel free to flag me. I'm happy to entertain it. So over time, we have all kinds of parental choice that have happened. And if you think back to how all of these have evolved, In each case, they are in some way the state saying, in terms of their Parens Patriota authority, we're going to let go of it, right? We're not going to be so controlling. We're going to permit parents some of the control that previously we dictated by statute. And so over time, we have a whole host of parental choice programs. For example, homeschooling that's listed second. In 1980, only 2 states permitted homeschooling in furtherance of compulsory ed requirements. Only 2. Now all 50 do. So we've seen a big evolution of all of those kinds of things. You'll notice some, you might be looking at that and say, why does she have traditional public schools sitting there on the public school choice bucket? And that's because, again, we forget that there are a whole host of people. In my state, around 860,000 kids choose public schools in terms of where they're going. You had a question?
Yeah, excuse me. So I was thinking that, private schools and traditional public schools as well precede compulsory schooling laws, so that they existed before the states put them in. And I'm also wondering for homeschooling, there was likely parents in those other 48 states doing it. Are there any examples of states trying to enforce putting children in schools that were being homeschooled in those other 48?
Sure, I can't give you a name of one off the top of my head, but yeah, that happened. And it also happened, so they would be fined in the same way that you would be today for failure to educate your children. You might even think of, if you're familiar with the case Wisconsin versus Yoder, which is about Amish people. Those folks were doing just that. They were educating at home past 8th grade. That was they were being fined $5 a year. And that's what gave rise to that court case. So that would be, that one is even an example. But we also have a number of examples that look at, even with those states, as they began to have homeschooling, there are a whole host of regulations for homeschooling have been upheld. Homeschooling is permissible only if you have a curriculum that's pre-approved. Homeschooling is only permissible if you have a certified teacher doing the homeschooling. Homeschooling is only permissible if you allow the child to be periodically tested on the state tests, and if they don't do well enough, you lose the ability to homeschool. So all of those kinds of standards on homeschooling have been both challenged in court and upheld. So, point again is that this whole kind of milieu, if you will, of various choices have evolved over time. You're absolutely right. Before compulsory education, of course, we only had private education, and then public education started, and then we had private schools, and then by the end of the 1800s, all states had compulsory ed statutes. So some common questions I hear. I do a lot of speaking to local community groups. In fact, next week I go to Green Bay to a League of Women Voters who's asked me to come and speak. And if that talk doesn't happen to be about vouchers, but when I come talk about vouchers, these are the common questions that people ask me. And if you're looking at that slide thinking, what in the world does she have a picture of a wagon wheel there for? That's a linchpin. If you don't know what that is, that's a linchpin. And the linchpin that helps us untangle or answer each of those questions is the exact same linchpin. That legal linchpin, in fact, is the 14th Amendment. So the 14th Amendment and how the Supreme Court has interpreted it, and the jurisprudence along with the 14th Amendment, both the Equal Protection Clause and the Due Process Clause, really help us to answer each one of those questions. So let's try that a little bit. And to do that, again, historically, the very first cases around vouchers had to do with the Equal Protection Clause of the 14th Amendment. Why? Because after Brown versus the Board of Education, Brown 2, where the Supreme Court ordered that systems of segregated schooling be dismantled with all deliberate speed, there was a lot of deliberation, but not a lot of speediness, right? A lot of speedy deliberation in the other direction, perhaps. And what you saw was the rise of choice academies, sometimes called segregation academies, because they were created as a way to thwart desegregation orders. And you even had Prince Edward County And Maryland goes so far as to say, all right, if we have to desegregate public schools, we just won't have them anymore, closing all of their public schools, as a way, again, to subvert the Supreme Court's order in Brown 2. 1964, the Griffin case invalidated that. So the Supreme Court said, doing that, closing public schools and giving vouchers, knowing full well that the vouchers are only available to the white students in the county, is a violation of the 14th Amendment itself. So we're still in the violation of the 14th Amendment and its Equal Protection Clause. A little later, you get Greene County. This is Kent County in Virginia. And Kent County said, well, we'll just do it by making all of our schools open to everybody, and anybody can choose whatever school they want. Again, the Supreme Court said, wait a minute, you had a constitutional violation, and this choice plan is an insufficient answer to that constitutional violation. You can't do that. So our first choice, if you will, initiatives were both tethered directly to the 14th Amendment and the equal protection grounds, but as ways to get around the order to desegregate public schools. After these cases came out, and the Supreme Court was fairly firm, very firm in their decisions here, what you saw was not any more litigation around the Equal Protection Clause so much as you began to see litigation around the Establishment Clause. Can we, or can a state, or could a state create a voucher program that was permissible without violating the First Amendment's prohibition against establishing a religion, since the majority of private schools, both then and now, were religiously oriented. And so following that, again, a little history. Oh, yeah, just if you haven't read this book, this is a fabulous book. So if you haven't read it, you know, something must be done about Prince Edward County. It's a really good book about the author's family actually was involved in those decisions. So I highly recommend it. It's a good book. One of those historical books that reads like a novel, which is always good. I like that. Okay, so to understand, though, the 14th Amendment and this notion around religion, we still have to look at that First Amendment and what the First Amendment says. And what do you notice about that lovely language there? Anybody notice something there? Who is the First Amendment controlling? Congress. Huh. Congress, well, the state of Tennessee or the state of Wisconsin, that's not Congress. So how did this all happen? How do we even pay attention to the Bill of Rights in public schools if the Bill of Rights starts with the word Congress? Well, that happened, again, because of the 14th Amendment. And here, for all the graduate students in the room, shows the importance of a footnote. Footnote 4 of Caroline Products, which is a 1920s case, where whoever wrote that lovely footnote said, hey, but wait a minute, the 14th Amendment prohibits the denial of the privileges and immunities. Privileges and immunities are certainly things like the Bill of Rights, right? Free speech, free press, all of those kinds of things are privileges and immunities. So states cannot deny those privileges and immunities granted by the Bill of Rights. So in that way, we talk about the 14th Amendment being the conduit through which all of those other rights are made applicable to the states. All of those other rights then have to be paid attention to by policymakers at the state and local level. So the First Amendment and its prohibition against our 5 freedoms, right? I won't test you, but your 5 freedoms. So you've got religion, speech, petition, assembly, and press. Your 5 freedoms. All of those, the Fourth Amendment, and then of course we're talking about due process, all of that happens to be applicable to the states through the 14th Amendment. So if those of you who are reading case law and you know that it's a First Amendment case, and you notice that they say a violation of the First and 14th Amendment, and then all they talk about is the First Amendment, that's why. It's because it's a violation of the 14th Amendment by violating the First Amendment. So that's how we get there. So starting with issues on that religion and looking at vouchers and whether or not states can create those systems consistent with the First Amendment. We, of course, in 1971 get the lemon test. When else can you get to say the word prong, right? Unless you're deer hunting. Prongs, right? The three-pronged lemon test. And it asks those three inquiries, and all three have to be answered in the affirmative in order for it to pass constitutional muster. If you fail any one of the inquiries, you failed the Establishment Clause. And so that test, although greatly maligned since 1971, has never been overturned and is still used. Supreme Court sometimes pays attention to it and sometimes ignores it, but the lower courts have to pay attention to it because until the Supreme Court tells them they can't, they have to as a precedent. So those three inquiries, legitimate secular purpose, primary effect that neither advances or inhibits religion, and finally the excessive entanglement prong. Those three inquiries guided all of those early iterations of aid to private schools. And in fact, the first big case then becomes the Nyquist case. So this is a New York statute that provides various kinds of aid to private schools. And interesting, even though it has a lot of characteristics that are similar to the case, or similar to the program ultimately upheld in 2002, many years later, the Supreme Court here considered it a form of direct aid. So they considered it a form of direct aid. They invalidated it as direct aid. You have the quotation from the court right there. Because it violated the effects prong. It had the primary effect of advancing religion. Once the Nyquist case came down, there was a general assumption that that doomed vouchers, that Friedman's idea could never fully be examined because the Establishment Clause stood in its way. But, as often happens, jurisprudence evolved. And so you see the Nyquist decision in ways, or if you want to think of it this way, the wall of separation between church and state being chipped away. And we have 5 cases that really lead us there incrementally to the idea that perhaps vouchers can pass constitutional muster. It started with Mueller versus Allen, a tax credit case out of Minnesota. Then Witters versus Washington, which was a case about disability rights for a college student. Then you had Zobrist versus Catalina Foothills, which was a case around whether or not under the Individuals with Disabilities Education Act, an interpreter could be provided for a deaf student at a private Catholic school. Agostini versus Felton, which had to do with Title I, as you see there. And then Mitchell versus Helms, which also had to do with Title I, but with things. So with those 5 cases, and so the first case that was appealed to the Supreme Court on the notion of vouchers was actually Jackson versus Benson, a 1990 Wisconsin Supreme Court case about the Milwaukee Parental Choice Program. And of course, I was waiting to see whether or not the Supreme Court would take Jackson versus Benson because, you know, as an academic, if you can get a good title for a law review, everything's great. And I was just waiting to use the Jackson 5 because we had that. But the Supreme Court thwarted me, did not take Jackson versus Benson. Title went away, darn it. Oh well. And in fact, they denied cert when the Milwaukee case was appealed to them. But a few years later, we get Zelman versus Simmons Harris. So this is the Cleveland voucher program out of Ohio, patterned after the Milwaukee program. They're very similar programs. And you have the Supreme Court saying, no, the Establishment Clause is not a problem. Why isn't it a problem? Now, interestingly enough, they did not overturn Nyquist. Instead of overturning Nyquist, just saying we got it wrong in Nyquist, instead what they said was Nyquist was direct aid, this program is indirect aid. Because this is indirect aid, we're going to look at something a little bit differently. And so as you see there, The assistant goes to a broad class of citizens. So in other words, the recipients were considered the parents, not the private schools that ultimately got the money. And because the recipients, those private parents, direct the aid, it's not a problem. Because any religious, if you will, message is reasonably attributed to the recipient of the aid, not to the state. If you go back and you read Zelman, you'd see that Justice Stevens had a very short, about 3-paragraph dissent, where he basically chides the 5-member majority for missing the forest for the trees. Because what he says is, people, they started the program. That's the only state action you need. But of course, that was in the dissent, right? His view did not hold sway. So you also then see this 14th Amendment link again, because we're focused directly on those words. No state. Private individual is not a state. So you see then that the court considers that a circuit breaker. The circuit between government and religion was broken. In other words, the First Amendment is a prohibition on government because individual private people are directing the aid and they have the free and genuine choice, is what the Supreme Court said. Then, in fact, that circuit is broken and the Establishment Clause doesn't apply. So what they're saying there is that if there's no state actor, there's no Establishment Clause. Hold on to that, because if there's no state actor and there's no Establishment Clause, there's no state actor, there's also no free exercise issue, there's the state actor, there's also no issue around the Fourth Amendment and search and seizure, you can keep going, right? No state actor, all of those things fall by the wayside. And in fact, so this is embarrassing to put up there because I am clearly demonstrating to you I am not a graphic artist. My youngest of 3 daughters are starting to study graphic design, and I said to her as she drove me to the airport yesterday, you know, if I'd been thinking, I would have made you redo a whole lot of my pictures in here so they looked like they're supposed to look instead of, you know, your mother's inept attempts at depicting something. But what I'm trying to show you here is that that circuit breaker logic, in other words, that the parents kind of cure the issue, has been used in at least 4 instances, 2 constitutional and 2 statutory. And so they've been used, so you can't, the Establishment Clause would prohibit you from directly providing religious school tuition. But if you introduce parent choice, you can get to the same goal, the same end. We can't segregate learning environments by race. That's unconstitutional under the 14th Amendment. But if you introduce parental choice, the court said in the Parents Involved case in 2007 that that's de facto segregation, and the ability of state actors to address it falls by the wayside. As Justice Souter pointed out in that case, that would permit someone to hide the ball, right? So as long as you don't say what you're after, you can get to that end. When we adopted the No Child Left Behind Act, there was one tiny little provision in there that said that the US DOE was supposed to redo the regulations for Title IX in order to permit, as an innovation, single-sex education. Again, the Equal Protection Clause and Title IX had both invalidated that earlier directly, but as long as it's voluntary and parents choose it, it's now permissible. 2004, Congress amended the Individuals with Disabilities Education Act to permit parents to opt out of special ed if they chose to, which has the effect of all of those non-discrimination requirements that school districts have to make, right? We promise we will not discriminate on the basis of disability unless parents give us permission to. And then we can. So that idea that parental choice changes the game, if you will, and allows for things that would be impermissible directly is a pretty big both legislative and judicial shift. In terms of school choice, this just gives you a timeline. So again, I've already talked about some things that started. You get both charter schools and the Milwaukee Parental Choice Program in 1990. Cleveland happens in between when Milwaukee started and Milwaukee expanded to include religious schools in 1995. And you also get the other ones, so both of which started, interestingly enough, in Arizona as a way to get around their state constitution. So their state Supreme Court said a traditional voucher program was unconstitutional under the Arizona Constitution. So Arizona legislatures came up with two end-arounds, if you will. They created the first tax credit scholarship program, and then they created an education savings account, both of which were challenged in the Arizona Supreme Court, or Arizona courts, and both of which were held to be constitutional.
Could you talk a little bit about why they were declared unconstitutional at the state level?
Sure. So at the state level, you have, and Arizona is not the only state, Florida, a whole host of them, and they neatly fall into two categories. So some voucher programs were invalidated by state constitutions because of the education clause. The way the education clause was written said that the state could not do this consistent with the education clause because of the requirement that they fund only public education, for example. So that you're looking sometimes at very arcane language about exactly what does that education clause say. The other group of cases have to do with the state's establishment clause, and they often have no aid clauses that are stricter. So if you think of it this way, if the federal establishment clause is here, and you have a state establishment clause that creates a higher standard, whether it clears this one, a la Zelman, is irrelevant if it doesn't clear this one. And so that's what happened in another group of states. Those, by the way, those no aid clauses, the Montana voucher program was recently invalidated on just that basis, and it's now before the the Supreme Court. It's Espinoza versus Montana Department of Revenue, I think. So in fact, I got a bunch of SCOTUS blog notices yesterday that a bunch of briefs had been filed, amicus briefs had been filed yesterday. So it's in the active briefing stage, but we should have a decision on whether or not it's permissible for a state, and these are sometimes called Blaine amendments, or occasionally you hear them called baby Blaine amendments, about whether that's permissible at all. So we'll see, we shall see. Okay. So just to give you an idea, prior to 1990, we only had two voucher programs, one in Vermont and one in Maine. And they were what we call town tuitioning programs. So these were places that were very rural places that frankly didn't have enough kids to often have high schools. They might have elementary schools like up to 8th grade, but then they didn't have enough to have a high school. So instead of having a high school with a dozen kids, they would give kids a voucher to go to a neighboring school district's high school or a private high school, as long as that private high school was non-sectarian. 1990, just after the Milwaukee Parental Choice Program was enacted, you see a smattering of vouchers, right? So you see voucher programs pop up in those states. Then notice what happens in the next decade. Few more. And notice what has happened since 2010. So now we're up to 28 states that have one or more voucher programs across the country. So what about student rights in those programs? Well, there you've got both, we have to consider both constitutional rights and statutory rights. What kind of changes happen when you have a voucher program to that expression of constitutional rights and statutory rights? Now, if you're looking at that list of statutory rights, those laws, with the exception of two, were enacted for the purpose of the prohibition of discrimination of some form. The others are funding statutes, but they have links to non-discrimination because they provide funds for various special populations. So both ESSA or IDEA both provide funds for special populations. So in that way, they're not divorced from a 14th Amendment link or a non-discrimination link, but their purpose technically is not non-discrimination, their purpose is funding. So different purpose. So let's kind of walk through, and so we'll start over here on the constitutional side. So on the religion side, of course, remember that you've got both the Free Exercise Clause and the Establishment Clause, and understanding, again, what happens in traditional public schools. What do we know about this law as expressed in public schools? And if we looked at all of the cases, of the Establishment Clause cases, or the religion cases, you'd find kind of three big buckets. So what I call the funding cases that have to do with some kind of tangible aid, the prayer cases, something having to do with somebody praying for some purpose, before a football game, before graduation, in a school, over an intercom. All of those are prayer cases. And then we have curriculum cases, when it's permissible to have religion in the curriculum. That's where your evolution cases are, for example. And all of that together tells us that that wall of separation created by the Establishment Clause between what's constitutional and unconstitutional, we're really looking at that difference between accommodation versus endorsement. Endorsement is on the unconstitutional side, accommodation is on the constitutional side. Figuring out, of course, which side of the wall you're on is not really easy, which is, of course, why we have so much litigation on this topic. If we look at free speech in public schools, we have 4 primary precedents. Again, I need my daughter and her graphic design abilities. But you walk through, so we have, in order of their enactment, it was Tinker, Bethel, Hazelwood, and Morris. But in terms of how we analytically work through them, we start with Hazelwood. And so what that tells us, and of course, Tinker being the most important, 1969, 50th anniversary of Tinker. A shocking decision for its time. Kids in schools have rights. Who knew, right? Kids in schools have rights. Now, again, you can argue that because of the carving away of Tinker with the other 3 cases, what's left of Tinker is a mere shadow of its first, its initial intent. But you still have that idea that schools cannot merely discipline or foreclose ideas and expressions of ideas that make them uncomfortable or about which they disagree. Kids in public schools get to disagree on a whole variety of things. Now, they have to do it respectfully, without profanity, and a whole host of other things. But they get to do that, unless they're trying to promote illegal drug use, and then they can't anymore. In terms of the Fourth Amendment, we likewise have 4 primary precedents that have established that, again, schools have limitations about what they can do around the search and seizure of their students. In general, we know that the schools don't have to apply by a probable cause standard. They have a reasonable suspicion standard that looks at both the reasonableness of the search at its inception and its scope. We have 2 cases that tell us that you can have random urinalysis for various privileges in schools. Not for the right of going to school, but the privileges. So that's how the Fourth Amendment has evolved over time in public schools. And then the 14th Amendment, in addition to the equal protection that we talked about already, is about due process. When is process due? And again, you have this case telling us that, in fact, we have to pay attention to the liberty and property interests of students. 14th Amendment, if you're remembering, has life, liberty, and property, but we're only paying attention to the last 2, liberty and property. And so we're looking at both substantive due process. Is it fundamentally fair to do that to a child, right, to exclude them often? We're talking about expulsion or suspension. And then what procedures do we need to go through to make sure we get the substance right? And so those procedures, at a bare minimum, have to be notice, a decision, and notice, hearing, and a decision based on the fact. In 1975, the Supreme Court tells us that, in fact, education is a property interest because of the rights-based position that students are in vis-a-vis their state constitutions, and that temporary suspensions, frankly, we're not going to make a federal case out of as long as you have those 3 rudimentary steps, right? Notice, I saw you doing something. I saw you smoking in the bathroom. Hearing, what do you have to say for yourself? And a decision based on the facts. I saw you, come with me, right? So it doesn't have to be elaborate, it just has to be there. But if it's more than 10 days, and this you're wondering, where's 10 come from? It's an arbitrary number picked by the Supreme Court people of the Supreme Court said, gee whiz, seems to me 2 weeks of school is a lot. And so golly gee, if you're going to take more than 2 weeks of school, you got to do more than that rudimentary kind of due process. Of course, they didn't tell us what, but state statutes have filled in that what. So all of that creates the rights-based position, right, that public school students find them in. And absolutely none of it applies to private schools and voucher programs, because the Constitution doesn't apply to private schools. A shocking thing to say, right? It doesn't apply. It doesn't apply. Why doesn't it apply? Because all of those are a limitation on the government. So if you don't have a governmental actor, you also don't have those governmental protections. So that means that we have to think about who is the decider in all of these things. If the decider is a public entity, then we have a state actor and all of those rights-based positions attach. If it's a private decider, we have no state actor and none of those rights-based protections apply. That means, go ahead.
Does that place a limit then, if I go with a voucher to a private school and I need particular services, can I return it, or do they, if they accept vouchers at all, do they have to accept me and provide services, or like how does that work?
Spoiler alert, no, but let me get you there.
Okay.
And what you have to do to figure that out is you have to start with, if the Constitution doesn't apply, what does the statute say? So vouchers are creatures of state law. So what a voucher is in Tennessee is not the same as a voucher in Wisconsin. It depends on the implementing statute and what the statute says. Now, as we talked about Parens Patriota authority, the state legislature can set standards that it wants. If you're going to take our money, here are the standards for taking our money. Right? But to figure it out, you have to look at that state statute to understand what those standards are around all of those dimensions. Eligibility for the individual child or family, eligibility for the participating private school, all of those kinds of things can be defined by that state statute. Now, remember though that the theory upon which vouchers are created was that government ought to get out of the way and ought not be regulating education at all. So it probably won't surprise you to know, building on that theory of action, that state legislatures have not regulated a lot of aspects around vouchers, because the regulation is supposed to come from the market, from parents choosing to go to a particular school or leaving because they don't like what has happened there. So let's start again back through those rights, and I'll start again at religion. So the first two programs have quite a bit in them about religion. This isn't surprising because remember, these were written before we'd gotten over that Establishment Clause hump. And so they were writing these statutes because they knew they were going to be challenged and they knew they had to get over that Establishment Clause hump. And so you have explicit language in these statutes that says that the private school provider may not discriminate on the basis of a religion. They have to allow anybody of any religion to come to that school if they're going to take voucher money. Wisconsin has an opt-out provision, so no child who's there by virtue can be required to participate in a religious activity. So they can come to the school, but they could skip Mass, for example, if they're going to a private school, Catholic school. Cleveland, Ohio, has a provision that says that the school cannot teach hatred of any person. Both also have requirements against any admission standards, so that essentially space is the only admission standard. If I have space, I can take you, but I can't turn you away on any other basis. And the other thing that they have is a random selection, so if it's oversubscribed, they have to have some kind of random process to pick, not a religious test to pick, but a random process. However, the new programs don't have this. And so one of the things that I've pointed out in some of my work is that we don't have a Supreme Court decision that says that vouchers without these elements are permissible. if you go back and you read Zelman, you'll see that a discussion of these elements was an important part of how they analytically got to where they were going. But we now have a number of voucher programs that not only do not have these protections against around religious activities of the folks using the voucher, they actually have language that could be viewed to go the other direction. For example, a participating non-public school shall not be required to alter its creed, practices, admissions policies, or curriculum in order to accept participating students. You know where that came from? Tennessee. That's in your statute. Statutes, plural. And that means then if you have a private religious school that requires as a condition of admission that you make a declaration of faith, that provision of the statute would say that's okay. You can require a declaration of faith. You can require that, as some private religious schools do, that the family attends church a certain amount of time. You could require faith-based discipline policies so that someone who is, for example, wrote a paper about, I don't know, abortion maybe, that in fact would be considered inappropriate because it's contrary to the tenets of that religion, that they could be disciplined for that. And even there are some private school policies that would, they usually use the term involuntarily, you're involuntarily withdrawn. Well, that sounds like expulsion to me, but okie dokie, if you want to use that word. Not for anything the student did, but because something the parents did that is contrary to the tenets of the religion. So this kind of language would suggest not just an absence of the non-discrimination on the basis of religion provisions, but actually a permission to have those kinds of policies that would use religious rules in terms of who could get the voucher or use the voucher or not. In terms of rights to free speech and due process, it depends on what the private school's policies say. Because for the most part now, where the Constitution doesn't apply, we are now substituting contract law. So we're paying attention to what parents were purchasing and what the school held out for that purchase, right? And that if in fact they think that the school is violating the contract, that gives them a way to go to court to challenge an expulsion or challenge some other action. But as you might guess, those are very difficult to win. A contract, just to remind you of what that contract is, but that means then that it's important that parents pay attention to what those policies are, what the handbook says, because all of that is really part of the contract and what they're agreeing to. Some states' voucher statutes have disclosure requirements, meaning that they require the private school to disclose all of that in advance of a parent choosing to enroll their child there. But that doesn't mean that the state gets to control what is in those disclosures, just that they have to disclose whatever it is they're doing. In terms of non-discrimination, which was around your question, those programs don't have to abide by the same non-discrimination requirements. So, and I wrote a brief with Suzanne Eckes, who's a professor at Indiana University, on this topic, and we used the metaphor of opening a door to discrimination, and we talked about there being three phenomena at work that make that permissible, where a school can say no to someone on the basis of a status characteristic. The first is that federal law defines discrimination differently in public and private spaces. So we've already talked about the 14th Amendment, which is the foundational principle of non-discrimination, doesn't apply. So then we look at federal statutes around non-discrimination, and as you can see over here, most don't apply at all, or if they apply differently. And I'll give you an example of that in just a minute. Notice too that you have a number of these laws, that only apply to recipients of federal dollars. So if the private school is not directly receiving federal money, these laws don't apply to them at all. You also have those 3 laws that have explicit exemptions for religious entities. So by having explicit exemptions from religious entities, that also changes, if you will, the game for a whole host of those private schools that might be participating in a voucher program. So let's look at special education as an example. Now, this one, I am currently, this semester, teaching a special education law class. So the idea that I boiled down all the requirements into one tiny box is kind of funny, because I am filling 15 weeks of lots of stuff around special ed law, and I won't even get through it all because it is that complex a set of laws, right? But in terms of public schools have to comply with the 3 federal disability laws, Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, and the Individuals with Disabilities Education Act. And they can't, of course, discriminate on the basis of disability. What does discrimination mean here? Well, you see all of those things. We have a child find obligation, so they have to evaluate every child, including those, by the way, who are in private schools by virtue of voucher or anything else. Public schools have to provide special education and related services, and they have to spend whatever money is necessary to get children to that foundational level of a free, appropriate public education, or FAPE. They have to even deliver some services through a provision we call equitable participation in private schools. By the way, they have to do that whether or not the private school is getting a voucher, even if that voucher is for special education. The public system would still have to provide some equitable participation to those students in those private schools. And that 0 reject, as they call it, principle applies, which means that there is no child with a disability too severe to not be eligible for service. We have to provide service for all kids with disabilities, no matter how they present in terms of their capabilities. In contrast, in private schools, IDA doesn't apply at all. To the extent it talks about private schools, it's about providing that equitable participation, or if the public school places a child in a private school in order to receive FAPE. So IDA doesn't apply. ADA applies, but a different title. Title III, not Title II. And Section 504 only indirectly applies because of the state is fully bound by Section 504, and that makes the schools kind of indirect recipients of that state aid, and so they have to comply with that. But notice the difference here. Avoiding discrimination under those laws, in other words, to be fully compliant with those laws, you only need make reasonable accommodations or modifications to existing programs. So if a child requires something special and you don't have it, you don't have to provide it, which means you can say no to that child. So you could either tell that child, no, we can't serve you, or you could say, sure, you can come here, but you're not going to get what you need if you come. And it's up to you. So in other words, what counts as discrimination? So as a legal matter, discrimination is a term of art. It's not the dictionary definition. It's what the law says it is. And what counts as discrimination in public spaces is different than what counts as discrimination in private spaces. So you do hear people saying, how can they turn away somebody and still get public money? And the private school saying, but we're complying with the law. And they're right, they are complying with the law. The law does not require them to do anything special. Second, state legislatures have largely ignored that issue when constructing their voucher statutes. Again, not surprising given the theory of action that they're employing, right, in terms of Milton Friedman's theory. And so to date, they've not included comprehensive non-discrimination, and I've given you actually it was in the Peabody Journal, so look at that. An article that Suzanne Eckes and I wrote, and Jessica Ohm wrote for the journal on this particular issue. And what we did in looking at all the voucher statutes and dissecting each of the voucher statutes is we looked at what kind of non-discrimination language they had. We looked at whether or not they required any service provision for kids with disabilities. And we looked at whether or not they required services for kids whose first language is not English. And really no voucher program did all of those things. In addition, they have some, I'll show you some other language. Tennessee, you do have may not discriminate on the basis of race, color, or national origin. That's Title VI. So sometimes in voucher statutes it says you must comply with 42 USC, I've forgotten the next number, 6,000. 2,000? 2,000. 2,000D. 2,000D. That's it. Look at that. Memory works sometimes. Anyway, but notice that a public school would have a lot more things after that, right? You'd have sex, you'd have disability, depending on the state you're in, sexual orientation, gender identity, all of those different things. Schools, even though your voucher program at the time we did this analysis was a special education voucher program, there's no requirement in your statute that there be any special educators at the private school delivering or taking the special education voucher. So, and in fact, if you look at your parent handbook, it's quite clear that the parents are fully responsible for determining whether or not this school has what your child needs, and the school doesn't have to do anything unless it wants to. In fact, students and families waive all their rights under IDEA. So by taking a voucher, they waive all of their rights, and there's no requirement that English language learning needs be addressed at all. A third phenomenon is that private schools have the authority to determine what programs to offer. So if the non-discrimination standards say, I only have to reasonably accommodate in existing programs, I can control a lot by determining what existing programs I have, right? And so the analogy I often use is setting the table. You set your programmatic table, and to some degree that dictates who arrives at your programmatic table. You also have a big difference between rules that require mandatory action, like what happens in a public school, versus rules that permit discretionary action, right? We all learn this when we're little. There's a big difference between mom saying, I'd like you to clean your room versus clean your room, right? One's mandatory and one's a little more permissive, and we take full advantage of that permissive. Well, you didn't tell me. You said you'd like me to, but you didn't tell me, right? Nobody teaches kids that. All three of my kids learned that very early, which means they had to train me on how to say it right. So at any rate, so that's a big difference. And of course, in the way we've written the rules, a lot of those issues around non-discrimination become discretionary on the part of private school folks. Now, to be fair, a whole lot of private school folks do it because they choose to, but there's a difference between doing it because you choose to and doing it because you must, as a legal matter. And of course, all of these laws that we have that compel public schools to do a particular thing were written before voucher programs existed. So it's not surprising that they're very blunt tools and aren't helping us much to think about, well, now what? The other thing, as I pointed out, and I'm sure that Matthew's classes walk you through all of the litigation that helped us to learn a whole lot of things, right? So Lau versus Nichols helped us to understand that public systems must address language learning needs. And then, you can keep going with a whole host of them. That was a lot of hard-fought litigation, hard-fought legal battles. And so the question is, are we going to have a similar kind of, as voucher programs begin to take more of the percentage of kids, are we going to refight some of those battles, particularly when you have that circuit breaker that I talked about before? And then it's very clear when you look at what's happening across the country that some groups seem to be more vulnerable than others, particularly our LGBTQ kids or kids who come from families that are LGBTQ, that they're more likely to be omitted from a whole host of these programs. So Suzanne and I recommended in the recent brief that there are some things that could happen with that legal framework. One is that amending federal anti-discrimination law to make sure, to say that public funding has to be delivered in a non-discriminatory manner. The second, we do have a predicate for this, explore whether governmental benefit should be withheld. We have some cases, the Bob Jones case, and then is it Norwood versus Harrison, I think, that had to do with private schools who would not admit kids on the basis of color, the basis of race, and the Internal Revenue Service then said, well, you can't have tax-exempt status. You can't be tax-exempt and do this because you're not serving the public good if you're doing that. And that was upheld by the Supreme Court. So perhaps we need to revisit that as a tool. And then also I think state legislatures have an obligation to say if they're going to create a public benefit, that benefit should be available to the whole public. So in terms of those questions that I started with, what's it mean for students' rights? Two very different systems, both publicly funded. Are the systems the same? Nope. What trade-offs? Well, in general, parents are waiving their rights to achieve choice. Now, you might say that's a fair trade, but they are doing that. They're having to waive their rights, their children's rights, to achieve FAPE. And contract law then replaces constitutional law. And that we do know that public funds are flowing to entities that don't serve the whole public. So I'm going to stop there and entertain questions. That was a lot of terrain. I covered half of Matthew's class in that thing, but there you go. What you got?
I have a question on sort of first off, thanks for speaking in your talk.
Oops.
I have a question a little bit about like the discretion in terms of like how the statutes are worded themselves to who they offer the vouchers to, of who the state can kind of like offer the vouchers to. If you sort of see like general trends in language, or like legally who are they allowed to, like the class of individuals that they're allowed to offer vouchers to.
Ooh, good question. Right, so Equal Protection Clause is generally about classifications, right? But the idea that the government never sorts us into classes, of course, is not true. They can sort us into classes all the time. As long as a general matter, unless that class implicates a suspect class in some way, right? The general standard is rationally related to a legitimate state interest. So you have some voucher programs that set income limits. You've got some that are only for certain cities. Your new voucher program has both of those, the one that hasn't been implemented yet. It'll be implemented in here, Nashville, and in Memphis, and I think you've got 200% of the federal free and reduced lunch level. So as long as those standards, and that has created classes of people, as long as that, again, a rational relationship, doesn't have to be a good relationship, it doesn't have to be the only relationship, it doesn't have to be the best choice, it just has to be rational, it would be upheld. Unless someone can say that, for example, it violates the Tennessee Constitution in some way. So you do have, again, you have some voucher programs that just serve a certain population of kids. You've got children of military families, for example. Kids in foster care, kids with disabilities, and then some that are local in terms of a single place, or you have some statewide programs. And then depending on, some have income limits, some do not. Interestingly enough, the voucher programs that have to do with kids with disabilities have no income limits. All the others do, but they don't have any income limits. Even in the states where there are other voucher programs, like the one I live in, have income limits. We have, so Milwaukee and Racine, the income limit is 300% of the free and reduced lunch level, poverty level. By the way, 300% of that level is more than the median income of a family living in Wisconsin, so it's hard to argue that is now a low-income program. It started as 185% of that level, but it's now up to 300. And the statewide program is currently at 220%. But if passed as predicate, that will probably bump up too in the future.
Special ed, so vouchers that are targeting special ed populations, do those usually designate that the school, the private school that the voucher has to be used at is a special ed school?
Nope.
And so are parents aware that they're waiving their IDEA rights when they accept it?
Maybe, maybe not. Some statutes require that the State Department of Education create a notice of some kind to notify parents of that effect. Some do not. Ohio by statute requires that, and they have this lovely little side-by-side that says, you know, this is what you get in the public system, this is what would happen if you take the voucher. Our Wisconsin's special needs voucher program doesn't require that by statute, but the Department of Public Instruction has done that. Your parent handbook that goes along with these special needs voucher, and I'm blanking on the name of it, the individual something, IAP, right, thank you. I knew it was kind of a play on IEP, but it's, anyway. That one has language in that manual that makes it very clear that they're waiving their rights. But saying that waiving their rights and understanding what they're waiving may not be the same thing. So depends again on how the state has written the law. And of course you have to look at both the law and the regulations, because the two are supposed to be married to each other, but sometimes the regulations go a little bit further than the statute itself in terms of how you're going to implement. And remember, we call them regulations, but the real term is implementing regulations. They're regulations to implement a particular statute. So you'd have to look at both of those things to understand what a particular voucher program does. Yeah.
I have a question kind of about the, I guess, hypothetical limits of this.
Okay.
So from my understanding, there's certain private entities that are subject to constitutional limits when they're operating under the color of the law.
Yep.
So like hypothetically, if we were living in like Milton Friedman's dream and like everyone's going to private schools with vouchers, would then constitutional limits apply to those private schools? And is there kind of like a gradation there?
Well, you know, one of the things that I've argued is that state constitution education clauses are not general, they're specific. And so even if you look at the litigation that has happened under those constitutional provisions and that's been upheld, and again, I keep using Wisconsin as an example, but we have a long, rich history, so it's a good example. They upheld the voucher program by saying there's, you know, in that lawsuit, there's no indication that the legislature is abrogating its obligation under the constitutional provision to, what our state statute says, is to create a system of public schools as nearly uniform as practicable. So there's nothing to suggest that the legislature is not meeting its obligation here. As a discretionary matter, they can do something in addition to that. And they have to meet that foundation because the Constitution says so. But that doesn't mean they can't do stuff that's over and above what they're constitutionally obligated to do. So they can, as a discretionary matter, do something different. And so vouchers were upheld as an expression of that discretionary action to promote the general welfare. And this is true in not just in Wisconsin, in a whole host of states that have upheld it. The Indiana lawsuit, Meredith versus Pence, does the same thing. My point is that you know, and it's the name of the law review is the right to an education or the right to shop for schooling. So you can find it if you want to. It's in Fordham. Anyway. The logic then suggests to me that if you had evidence that shows that they hadn't met their constitutional obligation, that then that discretionary action would be improper, right? So that unless they change their constitution, they can't totally kind of say, you know, we're out, you're on your own. because the Constitution in almost all 50 states obligates the state legislature to do something around public education. So it's kind of like, you got to do your homework, make those public schools worth choosing before you can play in voucher land. So whether or not we've, in various states, you've hit that point where, in fact, the first system, the constitutionally obligated system, has been subverted by a legislative choice to fund private education, that may come down the pike. Hasn't yet, but it might come down the pike. So depends on if they change, of course, if they could get a constitutional amendment changed or get their Supreme Court to say, gee, our education provision of the Constitution doesn't mean that, then you could realize Freedmen's Dream. Right? It probably still wouldn't be under color of state law. And in fact, your statute, in as example, your statute has an explicit provision that says, accepting voucher students, the participating school, nothing is done under color of state law. It explicitly says that. So in case somebody tried to invoke that, there's, they put that in there right away. So nope, that's not what this means. We're not doing that. So, does that answer your question?
Yeah, thank you.
Yeah.
I have a question about policy diffusion. So you had a slide up there about the states that have adopted voucher or voucher-like legislation in recent times. And so I'm wondering what you can tell us about just kind of regional trends. So I noticed that most of it is on the right side of the United States, maybe concentrated in the South, just visually speaking. So what is it about, like what are the regional factors that research says or that you've come across that might be driving this?
What do you
Some
think?
regions and not others. I mean, I think, so,
What would your guess be?
I mean, I think about other studies of diffusion of education laws, like charter school adoptions. I don't think that one's quite as strong as what we see with the voucher adoptions. So I guess some regions want more separation from federal.
I'm grinning just because, yeah, think about, think about who's been in control of those states.
Okay.
Think about those state legislatures. And then you also have this other organization called the American Legislative Exchange Council, ALEC, which created a whole series of model bills, many of which are the foundation for the bills that were enacted. So those ALEC model bills that people then took home to their state legislatures after the ALEC conference, you see enacted across the country. So you can see that happening as those model bills were developed. You see them being enacted by legislatures across the country. Yeah. Anybody else?
A question. So something you mentioned made me think of when you were talking about the IRS and kind of that workaround.
Yeah.
It made me think of a news story that had nothing to do with vouchers, but it was about a school in Michigan where it was a Christian private school that Betsy DeVos is the school that she went to, and it made it
Or funded, not went to.
correct. There was a young woman who was sexually assaulted, and her family was trying to bring the case to the Department of Education and was getting nowhere. But they were able to bring it to the Department of Agriculture because the school was part of the National School Lunch Service. So again, this is a non-voucher example, but of a way of a family finding a workaround to get some rights. So I'm thinking, what other federal agencies do you see being a part of your recommendation of, helping students kind of get those rights?
Well, and where you went with that is that, that was the trigger. Remember those laws that, recipients? So if you can find a way to show that private school is a recipient, a direct recipient of those federal funds, then those non-discrimination provisions kick in. So I'm not familiar with what you're talking about, but my guess was that some artful attorney said, wait a minute, they're getting direct money through the food stamp, well, it's actually a food stamp program that gives the free and reduced lunch program. Anyway, out of the Department of Agriculture, and they used that then as a lever to say, you're recipients, now Title IX applies. So
I'm just curious about, I find that really interesting that the IRS got involved, or are there any that kind of stand out to you that could be used in this situation?
I think the big ones that you usually think about, but you have to have that tether, and that's the difficult part, would be anyone that's giving you funding. You know, sometimes we go to the Department of Justice, for example, looks at ADA complaints in private situations. So again, depending on what you're doing, but as I showed you, the ADA compliance standard for private schools is so low, it's very difficult to argue they're not meeting it, unless it's kind of straight out, we just don't take kids here. But I'll have to think about that. That's a question I've never been asked, so I'm going to go back and think about that. What other agencies might there be other than education, justice, agriculture that might kick in? So, good question.
Two separate questions. One, for private schools that are in states that don't require them to honor IDEA issues, I guess, would they argue that they don't have the funding to do so? Mm-hmm. I'm wondering, like, how close are the ties funding a child that has an IEP going to a private school versus a public school? Would they literally go out of business if they had to comply with those regulations?
Well, it depends again on how the statute was written and what they require. So, and remember that in some cases, the voucher itself is for special education, so it seems a little odd that you take a voucher and don't have to provide that thing that the voucher was said that was designed to do, but be that as it may.
I mean, the parent
in terms of
choose to go there.
Yeah. So there have been some discussion of that. Indiana actually has a voucher program that does have some provisions around kind of a traditional voucher program that if you take the voucher, we're going to provide some IDA funds. You could also do a whole host of other things. So for example, you could both fund it but order the public system to serve the private system. Now in some ways we're already doing that, which is a little odd, right? It's kind of a joke that it would be as though, because there are also a whole lot of provisions in these statutes that require the public school to advertise the voucher availability. So it would be like Target having to advertise for Walmart and then occasionally send personnel over to work in Walmart. That's kind of the system that we have right now. So that gets back to this whole, are you really in competition or are you not? How much competition is competition? It's interesting. Again, I'll use Wisconsin because we've got an interesting thing happening. The special needs voucher program is $12,400 and some, I think. I might have that. It's over 12,000. You can probably Google it and find it faster than my memory can find it. But, and again, the same thing. The school doesn't have to have any special ed expertise, nor do they have to provide special education, but they're going to get $12,000. And then some anyway. And if they do provide special education and it costs more than the $12,000, they can get up to 90% reimbursement for that amount above the special ed voucher. Public school reimbursement for special ed from the state is currently at 26%, and the biennium budget that was passed this summer is going to bump it up to 30%. So there's a fair bit of hollering by public school districts saying, hey, what happened to that 90? We like that 90 number. How about us? We'll take the 90. But that's not happening. But you're exactly right. That's one of the arguments, that if we're going to provide additional services, are you going to calibrate the voucher in order to permit that? Again, state legislatures can do that anytime they want to. Right. But so far they haven't done that. Same is true for English language learning services. And even though it is curious, I find it curious, that we do have a number of special needs voucher programs for kids with disabilities, we don't have any that are explicitly to serve kids with English language learning needs.
Quick second question. You didn't mention Trinity Lutheran, and I'm wondering how that plays into this. And I guess I'm kind of wondering how we think about just para-religious organizations. Sure. and how the funding works there.
So Trinity Lutheran, y'all know what Trinity Lutheran is? Okay, so Trinity Lutheran is a fairly recent Supreme Court precedent. And the issue was that a town had made funds available for fixing playgrounds. And Trinity Lutheran said, cool, we got a playground, it needs fixing, give us some of that money. The town said, no, we're not giving money to religious organizations, sorry. So Trinity Lutheran sued, said, if you're going to make this kind of general program available, you can't discriminate against us on the basis of religion. You have to allow, that money has to be able to go to us. And the Supreme Court, in a divided opinion, of course, agreed and said, yep, if you're going to make that, that available. Now, again, there's a school of thought out there that says that Trinity Lutheran decision means that any voucher has to permit religious schools to get the voucher, and that you couldn't have a voucher program like Maine's that doesn't permit religious schools. But there's the other school of thought is, but wait a minute, we do have long-standing Establishment Clause jurisprudence that says context matters, and that you have to pay attention to context. And there is a difference between building a playground or repairing a playground and paying for theology class and paying for all of that goes along with a religious education as a, because right now we have a case called Locke versus Davey, which was the last decision that Justice Nyquist authored in education. Go ahead and read it, but it's not terribly helpful, I gotta tell you. He talks about there being a play within the joints between the Establishment Clause and the Free Exercise Clause, and it's like, that's nice. How do I tell when I'm playing? Well, when am I in the joint? When am I not in the joint? And how do I tell how much playing I got to do? I mean, there's not a lot of direction in this decision, but what it does stand for is that what the Establishment Clause permits, the Free Exercise Clause does not necessarily require. So that difference between permission and requiring. I'm guessing, might be wrong, I'm guessing that the Espinoza case that's before the Supreme Court right now may give us at least some hints, even though that's not the exact question that's posed to the court. I think it's the first chance that they get to look at a religion case since Trinity Lutheran that has to do with some relationship to schools. We might get to see some indication of how the court views that very matter. If you look at some of the briefs, and I haven't read them deeply because, as I said, they just came live, but the quick scan I did, that very argument is starting to come up. So it's a good time to ask that question and see if you can find an answer.
Back to that special ed voucher, was it the state that was reimbursing? The state money, that would be the 90% reimbursement?
Right.
Wouldn't it end up being in the public school's interest to refer special ed students out of these voucher systems? And wouldn't that lead to like pretty substantial special ed segregation in schools?
It could. I don't think that, that would be a violation of Section 504 if that could be proven. And actually we've seen that phenomenon in charter schools. It's got a name, it's called counseling out, both counseling in and counseling out. So usually when they say counseling out, that's the charter school trying to get the kid with a disability to go back to the public system, where you got counseling in, where you have the public system saying, hey, hear about that charter school down the street, go over there. But that's a violation of Section 504. So, and that's been fairly clearly stated both in guidance and in some of the administrative complaints that have been decided on that matter. So if you did that, unless you hid the ball really, really well, that could come back to bite you. Yeah. Just besides that, it's just wrong. It's just not a good thing. Yeah, just wrong.
I had a question about, could you help me understand what a contract is? Because, I feel like I know in some sense, but now I'm wondering if I don't, because if something like a handbook counts as a contract.
Well, it comes through what we call incorporation.
Okay.
So the actual contract that they sign probably has a provision that says the parent agrees that they will abide by everything in the parent contract. So the piece of paper that's the contract doesn't say all that stuff, but it incorporates, it hooks in all the other stuff. Sometimes it just says we'll abide by all policies and practices. Well, that hooks in a big bunch, right? pulls that in. So it's usually done by incorporation. It's not enumerated in the contract itself, but that's how it happens.
And I guess does it matter, like the processes by like the actual enrollment practices? Because in my admittedly very limited experience enrolling kids in schools, those are the types of documents I don't see until after they're already there. So I'm wondering, it's like you're waiving rights that you haven't yet actually looked at those documents yet.
Yeah, well, that's one of those situations where, the presumption, and notice what you're signing, it's all that fine print we sign. How many times have you scrolled through the screen on your computer kit? I agree, I have read this. I'm not that fast to read, right? And in there, buried in there, is probably something that says all those different things that you've agreed to that you just scrolled by, but you just attested to the fact that you read them and you're knowingly signing this. Those contracts often do the same thing. And it becomes incumbent upon the individual to then say, hey, it says that these, I'm supposed to abide by this handbook. Can I see what's in the handbook? Again, as I mentioned, there are some voucher programs where the state statute says that in order to participate, the school has to make those things publicly available, either on their website or some other way, but it still is incumbent upon the parent to choose to read them or not to read them. And so you're absolutely right. They may have, in the same way that we scroll down and click that little button to get internet access, may have agreed to things we have no idea about, but once you've done that, you've done that. By the way, one of those things that's buried in there, it's probably an arbitration clause that says that if you have a problem, you're going to go to arbitration. You're not going to get to go to court. And it specifically says you can't go to court, that you agree to be bound by the arbitrator's ruling. Just saying. Yeah. Anybody else? And yes, I still scroll by. I'm very naughty. I just need on the airport's Wi-Fi. Yes. Yeah.
We talked about the rulemaking process.
Yeah.
So as we sit here today, we are moving through the rulemaking process for the Tennessee Education Savings Account / voucher law.
Here's your word for the day, for those of you who don't know. They're promulgating rules. That's what we call it, promulgation. Promulgating. There you go. Okay, so what are they doing with the promulgation?
Yeah, what would you be looking for? Where would you be?
So what I would do, what I have done, when I do this kind of statutory analysis is, start with the statute, and as you read through the statute, look for terms that don't have explicit definition. And so look for those terms that don't have explicit definition, and then as the regulations are promulgated, look to see if those terms then are defined in regulation. Sometimes, and that's true in federal law too, it's in the statute, it's in the regulation, and it's never defined. So for those of you who are into special education, we have the functional behavioral assessment and the behavior intervention plan that is not defined in either statute or regs, but yay, you figure out what you think it is. All right? It tells us we have to have some in some circumstances, but they don't define it. But that's what I would do. I would look for those terms, and then I would look, it is, when you do statutory analysis, it gets, in terms of legal research, you often are kind of chasing incorporation. So in the same way the contract might incorporate a handbook, a statute might say, will comply with, and then it just gives a statutory reference. Well, what is that referencing? So then you have to go to that one and figure out how that's incorporated and in what way is that incorporated. And oftentimes, when a legislature creates, for example, the voucher statute, they simultaneously are amending some of those other statutes. And so you may need to go look at that other statute to see what does that now say as particular to that voucher situation. So I'd be looking at incorporations, I'd be looking at terms and how they're defined or not defined. And then when you get the regulations, there is also going to be some other stuff in there just about how they're going to do things, and just trying to, having them, I literally have them side by side and kind of trying to find the link between that regulatory provision and what part of the statute is that implementing. Sometimes you have your state agencies will be really helpful, and they'll give you an annotated version. Well, they say this provision, and then they annotate it and tell you it's supposed to be implementing this part of the statute. Thank you to those people, because that makes your legal research a whole lot easier. But that's what I would be looking at, is those kinds of things.
Well, everybody, thank you for attending, and let's all give a great round of applause.
Thank you. This was fun.